Calling our last case of the day, Andary versus USAA. Good morning, council. This is a 20-minute grant. You have 2 minutes of a free fire zone and may reserve time for rebuttal. And please begin whenever you're ready.
May it please the court, Lori McAllister and my partner Jill Wheaton are here representing the defendants' appellants in this matter. I'd like to reserve 3 minutes of my time for rebuttal. 45 years ago, this court decided the case of Shavers versus Attorney General, in which you held that the courts can only force people to buy auto insurance if it is affordable and available to all. But as we all know, auto insurance in Michigan has been anything but affordable. We've had the highest rates in the country. People in urban areas have struggled to buy insurance at all at affordable rates. They can't afford to buy cars because they can't insure them, or they simply drive without insurance. There have been multiple efforts to reform the act over the years, all of which have failed with regard to affordability. One of the major drivers of creating an affordable system is the price of health care. The prior system created a perverse incentive for predatory pricing by providers. They could charge most of their patients one price, but yet charge a multiple of that price when they were dealing with their no-fault patients. The bipartisan legislature and the governor finally addressed this by putting some meaning to the word reasonable when they set the fee caps in Section 3157 of the No-Fault Act. The caps are substantially more generous than we see under any other applicable system. They're more favorable than Medicare, Medicaid, workers' comp, and even private insurance. And it was working. We saw rates coming down, and we saw the driving public receiving a $400 per vehicle refund. And the reforms at issue in this argument today accounted for approximately 90% of that, according to the MCCA brief. This court has always held that the legislature can prospectively change statutory rights that the legislature itself creates. And that's what we're talking about here today. We are talking about statutory rights to no-fault benefits for care that is rendered after the passage of reform. And if the legislature is unable to prospectively address care and deal with existing claimants as well as future claimants, then the system can never be brought to a meaningful reform situation, and we are always going to struggle with a system that borders on being unaffordable under Shavers.
But counsel, isn't the issue here, though, that people are relying on it? We're talking about folks that, within the time period that we're talking about folks who rely on this, and this would be a complete upheaval to folks in that regard, wouldn't it?
Well, no, Your Honor, for a couple of reasons.
Please.
First of all, these are not vested benefits under the law. These are statutory rights, and under this court's authority, if it is created by statute, the case law is clear that those are statutory rights that can be modified by the legislature.
But it's not
Secondly,
wholly statutory, right? It's contractual. So that you cannot claim the statutory right if you don't have a contract for insurance that enables you to. And that was a legislative choice, right? That, like, as opposed to comp, where it's a statutory right to a benefit. Here, the mechanism for enforcing those statutory rights is a contract of insurance. You need both.
No, not necessarily, Your Honor. Because
you don't need a contract?
No, because there are situations under the statute where you are granted coverage under the statute
Because
for certain.
Because someone had a contract.
It could be because someone had a contract, but not because you had a contract, which gives you rights on which you have relied and therefore had any ability to form a reliance.
Sure, maybe. So,
Which
I
is
mean,
just
I'm
like
just saying
the
it's
workers'
not
comp system.
wholly statutory, right? I think I
Well,
don't
what
think it's
the-
really helpful to understand what the effect of the statute is by saying that there isn't some contractual right implicated, whether it's your own contract, whether you are somebody, in fact, if you don't have a contract, you can be excluded from collecting statutory rights, right? If you don't insure your own vehicle, even if
If you
you're.
personally don't have one, then you personally are excluded from
So, I mean,
rights.
contract is in the mix there, right? It's not wholly statutory.
The same is true of workers' comp. A contract is in the mix, because unless there's a contract between the employer and the workers' comp insurer,
But of course,
then
the
there
employee
is
doesn't
no.
enter into that contract, right?
Pardon
In
me?
workers' comp, the employee isn't a party to that contract.
The employee has rights that result from the fact that there is a contract, just like Mrs. Andary, who is not a party to the contract, has rights because of the fact that there was a contract. Mr. Kruger has rights because his parents had a policy. So it's exactly the same. They are not contract holders in this case, but yet they are pursuing rights that, just like an employee would pursue, are in existence because of the fact that there is a statutory scheme which requires that when there is a contract, there are certain coverages that are required to be there.
So would
This
the
court said
analysis
in-
be different if Mrs. Andary was the named insured, if she was the contract holder? Would your position be different?
My position is that these are always statutory rights, and the fact that they get mandatorily put into contracts, because that's what the law requires, does not convert them into contract rights that are recoverable under and protected under the contract clause.
So could
And that's what Romaine held.
So could the legislature have said, we're going to change the reimbursement rate to $5 an hour, or, limit it, personal family care to 8 hours a week? The legislature was free to do that, and that would be fine, because it's statutory.
I think the legislature could do that because those are mandatory statutory benefits. And in that situation, then the court would do the kind of analysis that was done in the Romaine case, that was done in the Chambers case, that was done in Lottie versus Fostering, which says, we are going to look at this situation. Clearly, there's been an impairment here of some nature. Maybe it's severe, maybe it's not. We'll look at that, but we are going to then look at what is the public interest, what is the public good? Is this a valid exercise of the state's police power? And if so, do they have a legitimate interest in regulating this particular area of the law? And under Shavers, this court said that it is squarely within the police power of the state to be able to not only regulate the cost of insurance, but to be able to regulate the cost of medical care. And that the existence of auto insurance was not to increase the cost of medical care, which of course we all know it definitely has, because we know that they charge 5 times the amount for an MRI if it's a no-fault patient than it is for any other kind of patient that they are treating under any other
Isn't
reimbursement
the question, though, like,
statute.
I mean, and I don't disagree with it, and I think we can all accept that there are reasons for doing what the legislature did, and multiple competing concerns, and they decided on what they did.
Yes.
For those reasons,
Yes.
going forward, what we are asked to decide, right, is there a clear indication that all of those reasons apply to people whose benefits were for an accident who happened before the effective date of the statute? Right, so, I mean,
The
that
court
would have also
held-
been served perhaps to go back and to go forward, but we're looking at that, we need some indication to rebut a presumption that statutes passed apply prospectively. Like, so
Your
the
Honor, I don't
motivations of it
think-
aren't really the issue. The question is, what brings us to the sort of inescapable conclusion that those accidents that happened pre-June of 19 are included in the new statute that goes into effect? The rates don't even go into effect right until like July of 21.
Well,
Or
the
they
auto
did it.
insurance rates went into effect July 2020. The no-fault fee schedule went into effect of July of 2021.
Right.
So, yes, there are several indications in the statute itself. First of all is the language in Section 3157, where there's no exception made for when the accident occurred. All of 3157 is teed off when the treatment occurs, and it applies to all the treatment and rehabilitative care rendered after July 1, 2021. So we have language in the statute which makes no exception.
So is
And
it
that
language or is it an
a-
absence of language in 3157?
No, that language after is indicative of when it applies. And it's the same kind of language that was in Buell, where Justice Bernstein commented, hey, if we had language that had said after such and such a date, that would tell us that the legislature meant that this was to apply after a particular date to all cases current and pending. It's the same kind of situation. Secondly, we have the language in 2111 F8. And if you look at that language, it says, when you're determining your future rates, insurance companies, you are required to look at what savings you receive on accidents that predate the adoption of the No Fault Reform Act and pass those savings along from the application of the fee schedule in your future rates. If they don't apply.
Can I just clarify a point to make sure I'm understanding? The
Yep.
first point of that you need a date, doesn't 3157, I think it's sub 14, say this provision applies July 1 of, I don't know, there's so many dates bandied about, 21 or 22, right? Why is that language not sufficient to say this applies going forward from that date?
Because it says it applies to treatment or rehabilitation training rendered after July 1, 2021. So if you have treatment that's rendered after that date, it applies. There's no exception in the statute for treatment that occurs after that date, but the accident occurred before. So I think the language is very clear. And if you go to 2111 F8, I think it's even clearer. Because in F8, it says that an insurer shall pass on in their future rate filings the savings realized from the application of 3157 fee schedules and rendered to individuals who suffered bodily injury that occurred before July 2, 2021. So the legislature has said, hey, if you get savings from applying the fee schedule that we've adopted to those accidents that occurred before the fee schedule comes into effect, then you are required to pass those along.
But
There
there
wouldn't
a
be anything that
window?
would fit into this.
Excuse me, isn't there a window when the policies go into effect in July of 20? The fee schedules go into effect in 21. Why does 211 F sub 8 not, why isn't it talking about that period of time? Why
Because
does it
the
go all
fee
the way back to
schedule-
1995?
Because it applies for anything prior to the date of the implementation of the fee schedule. It doesn't say this only applies for savings that you get for accidents that occur prior to.
But do they need to say that if the presumption is that when you pass a law, it applies prospectively? So
For 2111
we're not
F-
even we're not even in the realm of these new things, but for the passage in June of 19 of the whole act, right? And then these policies go into effect with the new savings in July of 20, and then these fee schedules don't go into effect until 2021.
Actually, the policy started going into effect in 2019 after the act became effective. There were rate reductions that went into effect starting in 2021 then was when, that the insurers had to give. 2021 was when the fee schedules went into effect. The language in 2111 F8 says that the savings realized from, and then treatment rendered to individuals who suffered injury from accidents that occurred before July 2, 2021 are what have to be captured and passed on. If there's no fee schedule, there's no savings to be passed on. The only place in the code that has medical provider fee savings baked in is 3157. There's no other provision in all of the Reform Act where provider fees are addressed. And the other thing we have to keep in mind is these are not fee schedules that are in any way unfair or any way injurious to people. We're talking about fee schedules that are twice what Medicare pays, that they're more than what you get in Medicaid, they're more than what you get in private insurance. So what we have to do is look at the balance that the legislature cut here. They could have gone to a system like Justice Welch described, where they were very punitive, if you will, in terms of what they went to. They could have gone like every other state in the country and said, we're no longer going to have unlimited PIP benefits. We are going to, from now on, have limits of $10,000, and when you hit that, that's all you get.
Well, and I agree, they basically did say that moving forward. You know, that's what they said, and then you can buy extra policies and, you know, up to each person. But we're debating obviously about the people from the past.
Right.
And it does seem there is a split on what the legislature thought they were doing. I mean, we have amicus submitted saying that is definitely not what we intended. Are we,
Well,
what are
we
we supposed to
have-
do about that?
If I could address that briefly, Your Honor. The amicus brief that was submitted by the legislators, we submit is entitled to no consideration for a couple of reasons. First of all, the majority of the people that signed that were people that voted against the legislation. So for them to tell this court what the people who voted for it intended makes no sense.
Is it the majority? Was it all of them?
Not all of them, but the vast majority
Okay, so
are.
some of them, though,
Some of them
voted for it, but they're
voted
saying they
for
thought
it.
it was different.
If the way the legislature speaks is what acts they adopt. And the plain language of what they adopted, if they didn't understand it, it doesn't speak very well for the legislators. But the plain language of what they adopted said, if the treatment occurs after this date, these fee schedules apply. I don't think that was very hard for them to understand. This court has binding case, there's case law indicating that post-passage remarks of legislators are entitled to no weight. If this had been a statement that was made during the process, that would be one thing, but this is not the situation that we're facing. And in fact, there was an effort made at the very last minute before the final vote to do an amendment that would have put into the statute a provision that says that the accident date has to be after July 1, 2021. And that was rejected by the legislature. And instead, they put in the provision that I mentioned, 2111 F8, that said if there's savings from having it applied to these earlier accidents, you have to pass it on.
Well, why aren't we looking at that, though, and looking at those dates as that savings between June 11th, 2019 to July 2nd of 2021? The
Because
savings
there aren't any savings in 3157 that would kick in before July 1, 2021. If you look at 2111 F8, the savings that it asks you to look at are from the application of 3157 2 through 12. Each and every section, 2 through 12, does not take effect until July 1, 2021. And you can see that if you look at 3157-14 that Justice Kavanaugh mentioned, which says none of this takes effect except as to treatment rendered after July 1, 2021. So there were no savings that fit this definition of falling within 3157-2 through 12 except after July 1, 2021. I see my time is running away from me, so
Just real quick,
if
though,
I can
I'm going to go back
reserve
to
a few minutes.
3157. It looks like 7 and 10, those amendments became effective June 11th of 2019.
But they did not apply to any care that was rendered until after July 1, 2021,
Because of 2111 F8,
because of 3157-14.
14. Okay.
Thank you.
Franzato on behalf of the plaintiffs, appellees. With me at the council table are my co-counsel throughout this case, George Sinus and Lauren Kissel. Let me begin with where Ms. McAllister began, which was the concept of that this is purely a statutory right. That is completely incorrect. We wouldn't be here if Ms. Andary did not have a contract with USAA. We wouldn't be here if Mr. Kruger didn't have a contract in force with respect to citizens. It's basically as simple as that. There is a contract between my clients and the defendants, and because of that, to suggest that there is, in fact, these rights are solely statutory is completely incorrect. But I want to say something about this, because Ms. McAllister, when she's telling you about all of these statutory rights, which can be changed at the whim of the legislature, is referring to one particular branch of cases from, at least as she draws them, from workers' compensation. But as this court has said, it has long been the rule in Michigan that in workers' compensation cases, the law in effect at the time of the relevant injury must be applied unless the legislature clearly indicates a contrary intention. That is from this court's decision in Nicholson from 1985. It's cited in my footnote in my brief.
Why doesn't 211F sub 8 clearly indicate to the contrary?
That's, okay. Let me
That's
talk
the
about,
million-dollar question.
I like the question. By the way, I'm sorry, I should have said I waived all of this.
Oh, sorry, I assumed you
It's
did.
quite all right, because I
just
do
assumed.
waive. Okay.
Sorry
Now,
about that.
let's talk about 2111F. Okay, because 2111F is not part of the No-Fault Act. It's part of the insurance code. And to take one word from your question, and that is clear, because this court has made it very clear.
But it was part of the same public act.
Well, I'll get to that as well.
Okay, sorry.
Okay. The fact is that this court has indicated that when the legislature, since the legislature knows how to do it, they know how to make their intent to make something retroactive. Since they know how to do it, they have to do it clearly. So the fact is that Ms. McAllister has latched onto this one little bit of a statute, which is not even part of the No-Fault Act. But the fact is, if you go a little bit deeper into the insurance code, and this is 500.2105, which is passed at the same time, it says the amendments to this chapter made by this amendatory act that added this subsection apply beginning July 1, 2020. So we have another portion of the insurance code passed on the same day, which does in fact indicate that it's only talking about things beginning on July 1, 2020. The same thing is true, believe it or not, with respect to 2111F, because 2111F 8, the one that Ms. McAllister is relying on, begins with an insurer shall pass on in filings to which this section applies. That's the limitation. The filings to which this statute applies, as I've just read you from 2105, is in fact limited to that 1 year window beginning in July of 2000. And by the way, the same point happens to be made in the first subsection of what Ms. McAllister has cited, because 2111F1 says, before July 1, 2020, an insurer that offers automobile insurance coverage shall file premium rates for automobile policies issued effective after July 1, 2020. The fact is that there are two indications in the acts that were passed at the same time that the only thing that they were talking about was this 1 year period from July 1, 2020. So when 2111F8.
Okay, so could there be, I think, if I understand Ms. McAllister's point, is that even if we assume that's the case, there are no savings from 3157
completely incorrect.
between July of
No.
20 and 21.
No. Okay,
Where would that, how would
I
that?
walk into my insurance office let's say on January 1st of 2021, I enter into a one-year contract on January 1, 2021. The fact is that what 2111F8 says, since my contract is going to extend into the period where these reductions take place, the insurance company has to take that into account. That's precisely what they're talking about here. They're talking about a narrow one-year window. And there's additional information about this that makes this crystal clear that this entire argument is of no value whatsoever. And it's again tied to a legislative history, because there's something very unusual about 2111F, and that is it was part of both PA 21 and 22. It was, they were signed at the same time, but there was a slight delay in the passage of these two acts. But what's very interesting about them is that the version of 211F that was passed in PA 21, the one that didn't survive, was written differently. And what 211F said, in its original version in PA 21 was the following. The same language that you have to, all the language is the same until you get to this. Arising from injury from motor vehicle accidents that occurred before the effective date of this amendatory act. In other words, and that didn't survive. Why? Because 2111F8 in its final version, based on PA 22, changed that language to say before July 1, 2021. It changed that. But in its original version as passed, it had a version of this which would completely support Ms. McAllister. The original version in PA 21 of 2111F said that it referred to savings derived from accidents that occurred before the effective date of this amendatory act. So in the original version, the one that didn't survive, PA 22, there was a specific reference to events that preceded 2019 when this thing took effect. In other words, there was language in 211F in its original PA 21 form which would have completely supported the argument that Ms. McAllister is asking you to buy. That language was taken out. It was taken out to limit it only to that one-year window.
Or another way of saying is it was taken out because they wanted to ensure that it was that they had coverage for that situation in which you were talking about, where you get coverage partly before the effective dates of the rates and partly afterwards, that the insurance company has to take that into account.
Understand, if they had kept the language that was in PA 21 of 2111F, it would have said that there were somehow savings derived from accidents that occurred before June of 2019. That was taken out. And that was consciously, I would suggest to you, taken out because there were no savings to be derived from accidents that occurred before, in other words, accidents that pertain to my client. And you know what, the other thing is, in terms of legislative history here, the second point that Ms. McAllister has pressed upon you with respect to a clear indication, by the way, the fact that we're talking about 2111F, I would suggest to you, is part of the insurance code, is a pretty clear indication that this is not a clear indication of legislative intent to apply this thing retroactively. The second point that Ms. McAllister has tried to make with respect to a clear indication of legislative intent to apply this retroactively is, in fact, it fails for very similar reasons in terms of legislative history. Because what she suggests to you is that 3157, 7, and 14, the statutes that say we're going to impose these limitations on providers in treatment provided after July 1. That is, the suggestion's been made by Ms. McAllister, that is somehow a clear indication that this was supposed to apply. But first of all, I would suggest to you that since there's no indication in any of 3157 as to the treatment of people in the situation of my clients, that is, people who were injured before June of 2019, when this took effect, that's not a clear indication. But there is another piece of legislative history that demonstrates how completely erroneous this whole thing with respect to 3157 is. And that is the Senate version of what was originally proposed with respect to 3157. Because the Senate version of 3157, and I've attached it as an exhibit to my brief, the Senate version, in discussing, in providing for, just so you know, the Senate, when it changed 3157, sort of tried to adopt, I think, basically a workers' compensation standard. That's the way to look at it. But it did have a provision in it comparable to what is now 3157-14, the provision that says all of these provisions apply after July 1, 2021. But the important thing about the legislative history with respect to this is that the Senate version of 3157-6, that was sort of the summary, if you will, in the Senate version, said subsections 2 through 5 apply to treatment, training, product, service, or accommodation rendered after the effective date of this amendatory act that added this section, regardless of when the accidental bodily injury occurred. The point is that in the original Senate version of this, before it went to the House and there was a substitute bill, the original Senate version specifically said that the payments that were to be made under this new regime that they were establishing, they were to be made regardless of when the accidental bodily injury occurred. In other words, the Senate version specifically provided that the people in the situation of my clients would be covered by this change of law. The point is that this language, regardless of when the accidental bodily injury occurred, was eliminated by the House. It is not in 3157-14.
How does that support your, how does that support your argument?
Pardon?
That seems to cut against your argument.
Can you say that again?
That seems to cut against your argument. How does that support your argument? If it was in the Senate version and then it was,
Well, the point is, and I've cited to you a number of cases from this court with respect to this type of legislative history. In other words, there was a version presented to the Michigan legislature that would have clearly indicated that no matter when the injury occurred, these new changes to the law take effect. That's what the Senate version said, regardless of when the injury occurred. That language, which was in the Senate version, does not survive. It is eliminated in the House version, and the House version became what is now 3157.
So it appears there was language that was not adopted that would support appellant's position, and it seems like there was language that was not adopted that would support your position. I'm not sure how that helps us to decide what the
Well,
language
I'll
that
tell
was
you,
adopted
If it's
means.
a tie,
Well, this is what I want you to focus on, and it's not, I mean, I don't,
no,
I
no,
certainly
the
don't mean to,
point, the
let me just say, I certainly don't mean to make light of this case and the implications it has had and it will have for people, but our job is still to try to determine what the language means that was enacted by the legislature and signed by the governor. And I just want to understand your position that 3157, when it says that subsections 2 to 13 apply to treatment or rehabilitation, occupational training rendered after July 1, 2021, you're saying that's not clear because it didn't specify within that general category, give further description. It needed some further description. I'm trying to understand why that's not clear that it applies to all treatment or rehabilitation that occurs after that date, which is the import of the
What-
plain language.
I would ask you, what does it say about people who are injured before June of 2019. It says nothing. The fact is, it begs the question.
I agree with you, but how does that help your case? That's the question.
No,
Why does it need to say more?
We're dealing with a situation in which, in order to say that this applies retroactively, there has to be a clear and unequivocal.
Why does it apply retroactively? It says it applies to treatment or rehabilitation that occurs in the future.
Yes, that's certainly their
That doesn't
principal
look back.
argument here.
That doesn't
Okay.
look back, does it?
Okay,
It looks forward.
Okay, but the fact is that, and I'm glad you asked this question, because I would refer to you, obviously, to your concurring opinion in the Buell case. Because your concurring opinion in the Buell case makes it clear that this entire argument, with respect to prospective only, is completely erroneous. And you did a very good job, I thought, in the Buell opinion.
Well, thank you. Thank you.
You're welcome. You did a very good job of explaining what is or is not a retroactive application of a statute. And you even cited Justice Story's opinion way back in the Wheeler case to draw that distinction. And the fact is that this entire argument, that this is somehow prospective only, is completely inconsistent with this court's determinations of what is, in fact, a retroactive statute. Why? Because this court has said, and this is the Hughes case that I cited in my brief, and this is a direct takeoff, I would suggest to you, of Justice Story's opinion in Wheeler that you cited. A retrospective law is one that takes away or impairs vested rights acquired under existing laws, or creates a new obligation and imposes a new duty or attaches a new disability with respect to transactions or considerations already passed. In other words, merely because this statute may say that payments are in the future has no impact on whether it is to be classified as a retroactive application of the law. And why? Because, as this court said in Hughes, there are vested rights involved in this case.
When do benefits become payable under the statute?
I'm sorry.
When do benefits, between your hearing and my mumbling,
No,
it's
it's
really a
my
bad
hearing.
combination.
I confess. Okay.
When do benefits become payable under the statute?
Well, benefits.
I mean, it's an easy question, right? They're
Okay,
payable
because
as loss
benefits
accrues, when the
pay-
loss
I want to make it
accrues.
clear, and the distinction I would draw is between when benefits are payable and when they vest, when the rights vest. And what this court, it's the one sentence that I would impress upon you.
The statute tells us in 3110, the benefits payable for accidental bodily injury accrue not when the injury occurs, but as the allowable expense, work loss, or survivor's loss is incurred.
That's correct.
How do you get around that?
That's a question of accrual, when the cause of action accrues. But that's not the question.
So the right vests before it accrues?
Absolutely. The obligation to pay once it accrues vests much earlier. And the case that you should be looking for and the one sentence that you should be looking for is in the Clevenger decision from this court. Because Clevenger is a no-fault case. And in Clevenger, this court said, the rights and obligations of the parties vested at the time of the accident. That's a quote from this court. And in that quote, the court cited two Court of Appeals decisions, Kaysen and Madar, which stand for the proposition, both, by the way, both no-fault cases. They stand for the proposition that the determination of rights, of any rights under the no-fault contract are vested at the time of the accident. So the fact is that this whole suggestion that this is not a retrospective application of the law is wrong for the reasons you cited in your concurring opinion in Buell. And it's wrong on the basis of Hughes. This is a retrospective law because it takes away vested rights.
Can I switch gears real quick, because you're running out of time,
Okay.
and ask you a contracts clause question?
Sure.
Your clients were not the policy holders, right? They weren't parties to this contract.
It's irrelevant for this purposes in light of, there's a Michigan statute that says specifically that. they are
Third-party
covered.
beneficiary?
Well, the statute to look up is 500.31141. Because they are, by statute, part of this policy. 3114 sub 1.
Is there any, well, if anything, they're third-party beneficiaries to the
No,
contract.
they are not third-party beneficiaries. They are, by statute, entitled to benefits under the contract. They are not merely third-party beneficiaries.
Is there any case you can point me to anywhere in the country that says that parties in the position that your clients find themselves in can sustain a claim under the contracts clause?
Under the contract clause?
Yes.
I don't.
As not, I mean, they're not signatories to the contract, right? That I think you concede that.
They have rights by statute under the contract.
Okay, but they're not parties.
Well, I don't know if Ms. Andary is a named party in the contract or not, I don't know. But but it doesn't make any difference, certainly for Michigan statutory law.
Okay, I'm just, the contracts clause is a certain type of a claim, and I'm trying to understand if any court anywhere has recognized a claim by a non-party to a contract, that type of a claim. I haven't found one, I'm just wondering if you have.
Thank you.
No-fault reform is sort of like a sweater. You pull one thread on it, and the whole thing is going to collapse. There are different pieces, different groups, all of whose interests were balanced by the legislature. If there is to be a modification of the rights, if they don't believe that they meant what they said, then they should make the decision in the legislative arena, not through the courts. There is nothing in the Constitution that requires, that makes it unconstitutional to require providers to charge their no-fault patients the same as they charge all of their other patients. And that is the crux of why we are here today. The state has the police power.
Do you agree with Mr. Gonzato that the vested right to obtain, to have benefits paid as they accrue, that right vests at the time of the accident?
I would refer, Your Honor, to the Romaine case, where expressly this court cited to White versus General Motors, where the court said that they recognized that the increase in the amount of benefits owing to a disabled employee, because it was a workers' comp case, differs qualitatively from a statute that alters the terms of the eligibility for benefits. And here I'm quoting, thus, the defendant's assertion that the amount of benefits specified by statute is a vested right and cannot be retroactively modified is unsupported by the case law.
When does
So the
priority get
eligibility-
determined?
I'm
When does
sorry?
priority get determined? As the
Priority
benefits are
gets
payable?
determined at the time of the accident. And that's when
So the
their
defendant's
statutory
obligation.
right of, that is when the statutory right in terms of where the insurer you go to make your claim gets determined. That's eligibility. Who are you eligible to claim benefits from?
In part because you have a
But the amount
contract.
of the benefits is not determined at that time. It's not determined until you go and get care. Because at the day you're injured, we don't know what kind of care you're going to need. We don't even know if you're going to survive for 1 year, for 50 years. We don't know what kind of care you will need, whether it will be reasonable, whether it will not be reasonable. And all the legislature has done is say, we're going to let you get care for your lifetime still. We could have been draconian, but we weren't. We're going to let you still get care for your lifetime, regardless of when your accident occurred. But there are going to be some fee caps put on providers for the maximum they can charge. And I submit the legislature has the right to do that, and the Constitution does not preclude it when we are dealing with a right that is guaranteed only by statute, which Mr. Granzato finally admitted after his colloquy with Justice Viviano. We respectfully ask that this court reverse the the decision of the Court of Appeals, which we believe was adverse to the plain language of the statute and the provisions of the Michigan Constitution. Thank you for your attention to this matter.
Thank you all. The case will be submitted, and we stand adjourned.